Hello, everybody. It's Roger Royce. I'm a partner with Haynes Boone, Emerging Growth and Venture Capital in downtown Palo Alto, California, and the host of the 10,000 Startups podcast. So just a quick one here on the importance of documentation. It always surprises me just how often, even now, it never ends. I see people come in with really good companies. They've gotten the team right. They've gotten the product market fit right. They've got investors lined up. They've got good technology, good IP, but they just never got around to documenting everything that they should. And they come into my office and say, now what do we do? Well, that's a good question because it may be that there's nothing you can do. It may be that your company is, pretty much dead on arrival because of what you've done, or maybe we can fix it. Let me tell you why this is the number one mistake that startups make and why it's so important and what we can do to fix it. So what are the common issues for businessmen who do business on a handshake and never get around to putting anything in writing? Well, number one, of course, is equity ownership. It's the nature of corporations that you need people and you need paper. And if you don't have paper, then your corporation isn't quite finished yet. And that's a problem because to finish it, you want to issue shares. And if we haven't done that because you've got some idea in your head of where ownership should end up, you might be very surprised when you get to the point where you have to document it as to what your co-founders think about your idea. So equity ownership, we really want to get that nailed down in writing with stock purchase agreements early on. And it's not even, that's part of it. That's half of it. Half of it is figuring out what the equity percentages are and getting that in writing. But also it's imposing vesting restrictions because you absolutely have to have an agreement on vesting for that to be enforceable. And do you know what I mean by vesting? That's the idea that you probably all have in your head that if your co-founders don't stick around with the business, they don't get to keep their stock and they don't participate in gains from the sale. Well, unless you put that in writing, it didn't happen. That's a vesting restriction. And if it turns out that you have a falling out with the co-founder and it's time to negotiate their exit, well, if you don't have a vesting provision in their documents, you're going to have to negotiate it at that time when they have a lot less incentive to give that to you. Thirdly, and this is a little more subtle, but it happens so often, even today, that it's worth mentioning. And that is that there is oftentimes one founder who is putting in a lot of sweat equity, maybe some IP, their contacts, their connections, their business plan, etc., and another person who's putting in a lot of cash. And the parties go on without documenting that cash. What's it for? Was it a loan? Is it for additional equity ownership? Is it something that should convert into additional equity ownership when you do a financing? You just don't know unless there's something in writing. And you can bet there's going to be a disagreement about what that was when it comes time to convert those funds or when it comes time for a financing. The founder who put in the cash takes the position that it was whatever is most favorable at that time, whether it be a loan that they get repaid, or if it's more equity ownership that they increase their percent. And the company takes the opposite position. And it's so simple. One little corporate resolution, and we know what the parties intended. Now, I want to mention just a couple other things, because these days it's just so easy to go online and get in all sorts of trouble. And there are good documents online, provided that you know what you're doing. And the trouble is, most of the safes that you download, they might not say what you think they say. You might think you're getting a very company favorable instrument because a safe, simple agreement for future equity is generally company favorable, but you might have downloaded the investor favorable variety, which is, by the way, the one that is most widely available on the internet. That's the one you're most likely to download, the one you don't want, the post-money safe if you're a founder. So super careful about that. Just because it's easy doesn't mean you should do it that way. Secondly, almost everybody is incorporating themselves these days with online incorporators. And that's not a problem until it's a problem. And it's a problem when you don't execute everything that should be, like these vesting restrictions, or maybe a good solid IP assignment, or maybe you don't want an IP assignment because you've got IP sitting offshore or something like that. So you have to be super careful with the documents. You really have to know what you're signing and what you're getting in for. And most of these issues can be cleaned up. They can all be cleaned up, other than the tax issues, of course, if all the founders are in agreement. But once you have a disagreement, then you have a dead on arrival issue, because the founder who's no longer part of the company doesn't have a whole lot of incentive to play nice and be cooperative with the two that are staying behind. But let's say he has less incentive than they had before. That doesn't mean you can't negotiate something. It's just going to cost you a lot more money and work and time. Now, two things to keep in mind. An unsigned agreement is not an agreement. We talk about documentation. I hear that all the time. Well, look at all these unsigned drafts we exchanged. We just never got around to signing them. Well, you're going to have to prove that people actually relied on those. And there is good law that says if everybody relied on an unsigned document, you can treat it as signed. And I won't get into the technicalities of how you get there, but you can get there. But it's a burden of proof issue. It's a difficult issue. Why make your life so much harder? Just sign the stuff. And then secondly, when it comes to signing things, it's surprising how little you need to have in writing to have an enforceable agreement. One of my first lawsuits back when I used to litigate was literally a napkin that the parties had signed. And the party who didn't want to have it enforced because they were going to owe some money said, that can't be an agreement, it's just a napkin. And we sued them, and the judge said, oh yeah, that's an agreement, pay up. So it's surprising, what can actually be enforceable. This is Roger Royce with 10,000 Startups on the importance of documentation. Thanks for watching.